BetSedec is an LA-based community nonprofit that provides justice, stability, and hope to those experiencing economic and social disparities. BetSedec provides free legal services, educates community members with the powerful knowledge of their legal rights, and uses our collective voice to reform systems. Our vision is to achieve equitable access to justice so that everyone can meet their essential needs and lead fulfilling lives. Small businesses are a key part of local economies and infrastructure. BetSedec's Small Business Development Project supports small business owners through legal representation and educational resources. We partner with the County and City of Los Angeles, pro bono attorneys, business community groups, and economic development organizations to provide free legal education, resources, and one-on-one legal assistance to low to moderate income small business owners and entrepreneurs. BetSedec launched its Small Business Development Project in 2016 to strengthen the economic base of underserved communities, including women, disabled, veteran, immigrant, limited English-speaking, LGBTQ, and BIPOC business owners. BetSedec's Small Business Development Project can help small business owners and entrepreneurs with forming a business, leasing commercial space, understanding contracts, fair employee practices, protecting their intellectual property, and more. Contact BetSedec's Small Business Development Project by visiting lalegalhelp.org or calling 866-375-9511. We offer services in different languages. I am Marco Castaños. I am a staff attorney at BetSedec Legal Services. I work on the Small Business Development Team, or SBD. As part of BetSedec's dedication over 50 years to providing free legal services to low-income Angelenos, our team supports the legal needs of small business owners and entrepreneurs. This video was brought to you in partnership with the City of Los Angeles Economic and Workforce Development Department and BetSedec Legal Services. BetSedec is an equal opportunity affirmative action employer.
The Economic and Workforce Development Department's goal is to steer economic development in a manner that yields thriving businesses and creates job training and career opportunities for the City of Los Angeles. EWDD works every day to deliver a strong and committed workforce, maintain sustainable neighborhoods, and profitable communities throughout Los Angeles. Get more information at ewdd.lacity.gov. The City of Los Angeles Economic and Workforce Development Department, or EWDD, funds 10 business source centers across LA City. Business source centers offer free business consulting and technical assistance to help startups and operating businesses with permitting, access to capital, and marketing, among others. Services are provided at no cost to LA City business owners and resident entrepreneurs. Get more information at the link on your screen. Thank you for viewing this educational video. The information provided in this video is intended for general informational purposes only and should not be construed as legal advice. While we strive to present accurate and up-to-date information regarding small business laws and regulations in the state of California, laws are subject to change and may vary based on specific circumstances. Viewers are strongly encouraged to consult with a qualified attorney for advice tailored to their individual situation and to ensure compliance with all applicable laws. The content presented herein does not establish an attorney-client relationship, and we assume no liability for any loss or damage incurred as a result of reliance on the information provided in this video. You should decide which course of action is best for your small business after thoroughly discussing your case with a qualified attorney. Thank you.
Today, I am drawing attention to different business entity types. Establishing a separate business entity can be a very important step for business owners. We intend to educate our client community on the legal implications of operating different business entities, from least to most complicated. We'll talk about compliance and the necessary measures to keep your business entity in good standing, and we'll talk about concrete steps you can take early on in your venture that will set you up to make confident decisions about its future. These various business entities are essentially corporate entities. They provide ways to organize a venture partly or entirely apart from its owners. This is useful because you can pool resources, delegate authority, and clearly distinguish between assets belonging to the business versus its owners or members. Aside from corporations and limited liability companies, which are the entities we see most often, this conversation can also include nonprofits, trusts, and formal cooperatives. Together, these are common ways to organize assets and assign liability. This becomes relevant for small businesses because, as they grow, you need to have a plan for your profits, partnerships, or even succession. The different business entity types present different options for these, and a lawyer can help you understand the consequences of each. Among small businesses, from least to most complex, you have sole proprietorships, general partnerships, limited liability companies, and small corporations. Occasionally, we also work with APCs, or professional corporations. Even though there's multiple entity types, it's not that complicated to distinguish between these. And that's because they are all built from the same underlying principles. You either have liability protection or you don't. If you have or are seeking that liability shield, then you need to take some affirmative steps to operate the business outside of yourself. Ultimately, it boils down to how much each owner is personally exposed through the business's operation. Some of the entities that don't offer liability protection include sole proprietorships, general partnerships, and a certain aspect of limited partnerships, or LPs. A sole proprietorship is a business that's operated with no legal distinction from its owner. It's how many entrepreneurs we work with get their start. Although they often apply for and obtain a fictitious business name, or DBA, this does not create a separate entity and therefore does not afford liability protection. Sole proprietors assume 100% of the risk of operating their business. That means their personal assets are on the table in the event of litigation. Similarly, general partnerships are simply an association between sole proprietors. Each partner has the authority to bind the entire business, and each partner is personally liable for the risks assumed by the business. Although it is a good idea to have a signed partnership agreement between owners of a general partnership, this still does not create a separate entity and therefore does not afford those protections to its owners. In this conversation, we also have limited partnerships, or LPs. These are neat because we start to see some of the protections for certain business owners that are built into our laws. LPs must have at least one general partner and one limited partner. The general partner is responsible for the day-to-day management of the business. The general partner is personally liable for the business, akin to a sole proprietor or a member of a general partnership. The limited partner, on the other hand, cannot involve themselves in the day-to-day of the business, and as long as they are independent from its operations, they are afforded liability protection. They are liable only as far as their investment. Among sole proprietorships and general partnerships, the business owners are personally exposed because there's no legal distinction between the parties, especially among sole proprietorships. Everything the business does and owns is attributable to the owner, and vice versa. In California, some of the entity types that do afford protections include California Limited Liability Companies, or LLCs, and California Stock Corporations. These create a legal distinction between the business and its owners, so they can offer a means of protection for the owner's personal assets. LLCs are formed in California by signing and filing the Articles of Organization with the California Secretary of State. This is a document that says, hey, here's a new entity that exists. Your LLC is effective as of the date the articles are certified by the Secretary of State's office. It's also a good idea, especially among multi-member LLCs, to draft internal governance documents, including an operating agreement. Remember that the liability protection only exists because the business operates outside of you. How do you draft rules to show that, yes, the business is capable of operating independently of its owner or owners? The same goes for California stock corporations. These include S-Corps and C-Corps, which are merely federal IRS designations. The corporation is formed by filing the Articles of Incorporation with the California Secretary of State. Then you issue shares to the owners, draft and approve bylaws, and host annual meetings as necessary. Both entities in California also are responsible for the $800 annual minimum franchise tax, including the year of founding. This tax is assessed regardless of whether the entity is in operation or even profitable. This is what it takes to wield your separate entity as a buffer to your personal assets. If, as a business owner, you're considering establishing a separate entity, here at SBD we talk about at least 4 points to consider before forming it. What are your personal assets? How much do the business's operations actually expose you to liability? Does your industry expect you to have an LLC or corporation as a matter of reputation? And who do you want signing contracts on behalf of the business? If you have sizable personal assets, you may want to protect them from the liability incurred by your business, especially if you're in an industry with high risk. Another thing to consider, maybe your client base expects to deal with an LLC or corporation to reflect a degree of sophistication. And if you're signing contracts as a sole proprietor, then you are personally assuming liability for all the terms in the agreement, while signing as an agent of the separate entity gives you a degree of flexibility and protection. To recap some of the consequences of forming a separate business entity, the security afforded by the entity comes at a cost. In California, the annual minimum tax for these is $800. There are also modest renewal fees with the California Secretary of State, and generally, fees paid to lawyers and accountants to make sure your books are in order and you are following corporate norms. So if you're a business owner interested in assuming some of these protections without also incurring some of these costs, then yes, to a certain degree, there are other worthwhile strategies for protecting you and your business from lawsuits and liability. If you are a client-facing business, then take a look at your internal paperwork. Is it worth revising some of those forms that you have clients fill out? Perhaps you can have an attorney draft liability waivers, authorizations, acknowledgements, or consent forms. These could protect you to the extent enforceable and potentially limit your exposure. Additionally, business insurance is a worthwhile investment across business models, industries, and entities. Your business insurance policies could include litigation services and funds to help you negotiate a settlement in the event of a lawsuit. These tools, having strong client forms and sufficient insurance, are relevant and useful for all business types. But let's say a sole proprietorship or general partnership that doesn't boast built-in liability protections could consider investing in these at the outset, especially if they're not ready to bear the annual franchise tax of $800. I want to talk about S corporations because it's a term that's thrown around pretty often, and there's some confusion about its meaning. The term S corporation or S corp arises in the context of saving on the federal taxes for your small business. It is not a separate business entity type. Rather, it's a tax status that you select with the federal IRS. You may apply for S corp status as an LLC or as a California stock corporation. It's meant to reduce double taxation by only taxing your business income when it's distributed to the employees, namely you. There are certain conditions that ensure only small, closely held businesses are eligible for the status. For instance, it has no more than 100 shareholders, and they are all either individuals or estates, with some exceptions. This means another LLC or corporation cannot be a shareholder of a business with S Corp status. Further, it has no non-resident alien shareholders, and it only issues one class of stock. On top of that, to continue enjoying the privileges afforded by being classified as an S Corp, you must pay yourself reasonable compensation. That means you are paid for the services rendered to your business, and that salary is subject to employment taxes. You need to make those payments first before you can take non-wage distributions, which are not subject to employment taxes. So now that we've talked about the different business entity types, I'd love to share what it takes to get one of them off the ground. If you've done the planning and have agreed that forming a separate business entity is right for you, there are a few steps. In California, you file your articles and statement of information with the California Secretary of State. These are web forms available online if you create a profile with the Secretary of State's office. You should obtain a free employer ID number from the IRS. This enables you to open separate business bank accounts. And you should prepare and sign an operating agreement or bylaws and other internal governance documents. These govern how your company will conduct business. In line with these documents, you should also elect or appoint the officers of the company in line with the operating agreement or bylaws. Finally, capitalize your entity. How is anyone going to believe that it's separate from you if your LLC or corporation doesn't have its own bank accounts or assets? If you're commingling funds between your personal accounts and business income or assets, then you are not maintaining that distinction between you and your business. This could result in no longer enjoying those liability protections. After you form your separate entity, you do have to stay compliant. Now, I mentioned the minimum franchise tax at the state level. That's due every year, including your first year, even if you're not profitable and even if you're not in operation. Locally, you may need to renew your business license or tax registration, and your specific industry may require renewals periodically. You also need to file an updated statement of information with the Secretary of State, every 2 years for an LLC and every year for a corporation. And corporations are subject to state and federal securities laws. They need to comply with annual meeting and reporting requirements to their shareholders, even if it's just a formality. Let's also talk about winding down. It's an important step in the lifeline of these business entities. In California, winding down or dissolution is at least a 2-step process. As long as all the members agree, then you file a certificate of dissolution with the California Secretary of State. Concurrently or soon after, you must settle all outside tax obligations with the California Franchise Tax Board. Get in touch with them early and often. For business owners that want to get started or stay compliant, there's a wealth of resources out there. I've mentioned the California Secretary of State a few times. Get connected with them and create an online profile at bizfileonline.sos.ca.gov. The same goes for the Franchise Tax Board at www.ftb.ca.gov. Another great resource is CalGold, which is a state-run website that tells you some of the permits and licenses required for your business depending on industry and city or county. That is www.calgold.ca.gov. And here at BetCedec Small Business Development Program, we are also equipped to handle and advise on these matters. In parting, I'd like to share a short summary of everything we've talked about. Many businesses across Los Angeles operate as sole proprietorships or general partnerships. These businesses do not shield their owners from liability. Business entity types that do provide liability protection include corporations and LLCs. However, in order to enjoy these protections, you must abide by corporate formalities and keep your entity in good standing. Other methods of obtaining these or similar protections include having strong waivers, authorizations, or consent forms for third parties, and having sufficient business insurance to cover your operations. S-Corp status is a useful way to save on your business's federal tax burden, but this also comes at the cost of maintaining compliance with federal requirements for small corporations. There is a useful resource for California small business owners at the CalGold website. You may visit this website to better understand the license and permit requirements for your business, depending on its location in California. If you still have questions about when to form your separate business entity, then I strongly recommend that you connect with one of LA City's business source centers. There you can connect with business advisors and mentors to help you draft your business plan. Working with that business plan, you can then identify when forming a separate entity would be most advantageous for your business. Thank you for following along this very important topic. If you have any further questions or would like to connect with us, please contact BetCedec's Small Business Development Project by visiting lalegalhelp.org or calling 866-375-9511.